And welcome to the Ask JP podcast, where we talk about the very important issues of the day. Today, we are continuing our series on criminal justice reform and the elections this fall. Today, we're focusing on the district attorney's race. Before us today, we have Mr. Gary Wainwright, who is a candidate for district attorney in the city of New Orleans. Gary has 3 decades of trial experience in the criminal court system. He was admitted to the Louisiana bar in December in 1989. He's a graduate of Southern Law Center in 1899, cum laude. Earlier, he earned his bachelor in business administration from Millsaps College, graduating magna cum laude. He joined the Orleans Indigent Defender Program upon graduation and defended citizens there for 2.5 years before going into quasi-public defense private practice. He is one of Louisiana's most fierce defenders of citizens' constitutional rights. Gary's also regularly lecturing at Loyola Law School on the drug war and its impact on our nation. Thank you so much for being here today, Gary.
Well, I want to thank you very much for asking me, PJ, but I think you had a Freudian slip there earlier. You said I was in the district attorney's race.
Oh, I'm sorry.
Well, it's funny.
It's my I've been doing district attorney's candidates. My brain just pops back and forth between the two. But you have been a candidate for district attorney before,
Right,
so
right. No, and I'm actually running for the judge's seat in Section K of the Criminal District Court. That's the seat that Judge Arthur Hunter resigned in order to run for district attorney. So it's an open seat.
Okay. Well, let's get started on our questions. The first question is, why do you want to be a criminal court judge?
Well, the first reason is because I've dedicated my life to the fight for justice, mainly for black men in the criminal district court building. And every person deserves an honest, competent judge who's experienced and knows the law. And I kind of backed into running for judge in this election cycle when I found there was a candidate who didn't meet the constitutional requirements to be a judge. I undertook the litigation all the way up to the Supreme Court, which agreed with my reading of the Constitution. And one of the important things about me, and you've known me for years, is I'm a very, very oriented towards citizens' constitutional rights and the preservation of citizens' constitutional rights. And that is actually the primary function of a criminal court judge, is to make certain that citizens' constitutional rights are protected, and I've always done that.
Well, I think an important thing for citizens to really grasp, because when you talk about people running for judge, especially criminal court judge, the only experience people will have with you is when they're in front of you as someone who's potentially charged with a crime. So if you give us a brief overview of what your philosophy will be as a judge when dealing with the various lawyers and citizens that'll come before you, that would be very illustrative to the people out there in podcast land.
I think the most important thing anybody can know about me is I'm a set of one. My cards, my stationery, and the way I refer to myself from the first day of my practicing law is I have always been a citizen's defense lawyer. I have never been a criminal defense lawyer. And I have tried for 30 years to get the people who do what I do for a living to quit referring to the people they work for as criminals. When you're brought into a courtroom, you're an accused person. And it's the responsibility of the state to present evidence that proves your guilt beyond a reasonable doubt. And so I'm a skeptic. I'm a person that believes in the concept of innocence. And I'm a person who's practiced in this area of law and practiced in that building for 3 decades. So I know all the lawyers. I know all the prosecutors. I know what's right. I know what's wrong. I know what works and I know what doesn't work. and I'm offering to the city of New Orleans the benefit of a lifetime of experience to show the city what kind of fair and honest judge I can be.
Well, and speaking on that, because you know all the players involved, can you give us your thoughts on the current state of the criminal justice system and how it plays out for citizens who are going through it?
Well, you know, I guess in the 90s, I was sort of like the canary in the coal mine because I have always talked about the unfair targeting of the African American community in the drug war. And so people need to understand that in 1979, in Louisiana, we had less than 8,000 people in prison. And by 2015, that number had increased to 45,000 people in prison. Our state became the leading political subdivision on earth in per capita incarceration. And it was a horribly, racist set of policies that were only targeted or mainly targeted at black men. And I have spoken up and I have fought this systemic racism my entire life. So when you want to talk about the criminal justice system, what you have to talk about is the over-militarization of the police. People like to talk about Afghanistan, the longest war, 19 years. No, the longest war is the drug war. And we're entering the 100th year of the drug war, and it has to be brought to an end. I lost your audio, PJ.
I got it. So,
okay.
oh, sorry. So, let me ask your opinion on a couple of issues that are very important to the citizens of the city and issues that will affect your position as a judge. The first is, what is your position on the cash bail system? And if you disagree with it, how would you change it?
Well, I'm not, of course, I've been a person who's railed against the usage of the phrase politically correct, particularly since it was Newt Gingrich and that ilk that created it to challenge liberal values. I am not one of these persons that has this hard, I guess, and you would call it today, left position about cash bail. I think that bail amounts that are reasonably responsive to the economic circumstances that reflect the severity of the crime are reasonable and responsible. Do I think that anyone without a significant record who is booked with a nonviolent crime should be held in custody? No, I do not. But we have a really a catastrophic situation facing the criminal justice system, not only in New Orleans, around the country, but more particularly in New Orleans, in that we have worked very hard and we have reduced our jail population to the bare minimum during this pandemic, with a lot of recognizance bonds, a lot of very de minimis bonds. As you know, as a legislator, there are crimes, anything that's listed in 14.2, which is our designated list of crimes of violence in Louisiana, those require cash bond by law. Now, does that mean $1 million? No. But it does mean that there must be a cash bond set for that charge. But we have approximately 250 men who have extremely serious criminal charges, who have bonds that they cannot make, who are accused of crimes of violence, who have sat in the jail now for nearly 7 months and haven't set foot into a courtroom and probably won't set foot into a courtroom until 2021. And so I personally believe something has to be done, a combination of reduced cash bonds and electronic monitoring to provide some relief to those men who have been sitting in jail in a COVID incubator for, at that point in time, a year. It's the only fair and just thing to do.
Okay. What is your position on mandatory minimums? Do you think that they're constitutional? Are they appropriate? Is there something that you believe as judges can do or should do to kind of adapt to the issue that statewide they're used pretty frequently to lead to enormous egregious sentences?
Mandatory minimum sentences are unconstitutional. And it's one of the tragedies that led to our country as a whole becoming the most locked up, quote unquote, free country on earth, is that beginning in the 80s with Ronald Reagan, we enacted a horrendous mandatory minimums for entire rafts of crimes. And so I personally believe mandatory minimums in most circumstances are not constitutional. However, as a judge just can't declare something unconstitutional, like, I don't like it, I declare it unconstitutional. A perfect example of that is back in 2005, there was a law that had been on the books in Louisiana since 1935 called drug offender second or subsequent offense. And this was a law that enhanced the minimum sentence for a drug offense to the maximum sentence as a minimum mandatory sentence. So if you were accused of possession with intent to distribute 0.2 of a gram of cocaine, and you had a prior possession of marijuana sentence, the mandatory minimum sentence was 30 years in prison without parole. That was horrendous. And I came across that law when I was reading law one day, which I actually like to read law, and nobody had ever been charged with that in Orleans Parish, and I knew it was unconstitutional. And I tricked a prosecutor in New Orleans into charging my client under that statute so I could do the work to get the statute declared unconstitutional, which ultimately I did. But lawyers had been, quote unquote, objecting to and, quote unquote, complaining about that law for more than 70 years, PJ. More than 70 years that unconstitutional law was on the books. And it took a lawyer who knew how to do constitutional litigation and the right set of circumstances for that law to be declared unconstitutional. Now, because some lawyers had noted objections to it, ultimately there was 135 men who were freed from prison when I got that law declared unconstitutional. So, knowing how to conduct constitutional litigation, knowing how to rule on a constitutional challenge so that a law will be declared unconstitutional by the Supreme Court, who are the only ones who ultimately have the authority, the Louisiana Supreme Court. Those are important attributes for a judge to have, and quite frankly, neither of the two people who are in the race with me have ever engaged in any actual systemic constitutional litigation. And I'd just like to hold this up because I know this will be warm to your heart. This is a book called The New Jim Crow by Thomas Aiello. And this book came out in 2015. Now, I just checked my emails and I searched 10.2 real briefly, and I pulled up emails going back to 2002, where I was talking to people about the unconstitutionality of Louisiana's 10-2 non-unanimous jury verdict. Finally, when this historian wrote this book, and he went and dug out the actual words that were spoken by the racist racist constitutional convention in Louisiana when they said, we're passing this law to maintain white supremacy now and forever. A lot of other people got interested all of a sudden in the 10-2, and you played a big part in shepherding through the constitutional amendment. But right there, that one took nearly 100 years.
130 years.
Right, I'm sorry, bad COVID math. 100, right. It took 130 years to undo that one, PJ, but God bless all of us who, care about justice and think, hey, if you're going to get life in Louisiana, the state should be held to the same standard as if they're going to try and give you life in Mississippi. It doesn't seem like that shocking a concept, does it?
It's Louisiana. So moving to the next issue, which obviously you'll have some impact on. What is your position on the death penalty as a judge? What is your position on death penalty as an individual and as a judge? How will you?
Well, I don't think the death penalty is appropriate under any circumstances.
Okay.
It's amazing that when we first invaded Iraq, one of the first things we did was we made the Iraqis abolish the death penalty because their criminal justice system didn't have enough integrity to guarantee they would be executing the right people. Well, over and over again, it's been demonstrated in Louisiana in particular that our judicial system doesn't have the integrity to undertake this type of litigation. And beyond that, it's incredibly bizarre. We don't have a thing like this. If you have cancer and you go to one doctor, you get to die, or, you have a lawyer and he didn't do a good job, and they'll actually write in the opinion, well, if his lawyer had done this, we'd have to give him a new trial. But his lawyer didn't do that, so we're going to kill him. And that's literally, they don't say it that clearly, but, that's what death penalty jurisprudence reads like. And now, the other thing I think is unfair, and I think is unconstitutional, is the process called Witherspoon. And in Witherspoon, the state is entitled. The state does not have rights. Citizens have rights. The state has authority and responsibilities. But somehow in the 80s, they whipped this thing around that the state has the right to a jury that will consider giving the death penalty. So when you're in a town like New Orleans that's very Catholic, that the Catholic Church says the death penalty should be abolished, and you start off with 100 people, and the first 80 get disqualified because they say, I could never give anyone the death penalty. Then you got the 20 people that say, I could kill somebody. That jury is not a representative cross-section of the city. And so I don't believe that Witherspoon was a properly decided decision. And I know that here in New Orleans, in the course of my career, I've actually represented 3 people in death penalty cases. And the most shocking one was I was representing a young man that was accused of murdering an NOPD officer, Tyrone Martin. And he had falsely even confessed to the murder, and he sat facing the death penalty for 2.5 years until the U.S. Attorney's Office called me up and told me that they had known who really killed Tyrone Martin for over 2 years, and they were about to arrest that person. And I was so, talk about mixed feelings. In one sense, I was so outraged because they'd let this young man and his family, be terrified that he was going to get the death penalty and didn't tell us for 2 years. Now, I was glad they stopped it from, I'm glad they didn't wait till he got the death penalty to tell everybody you're trying to kill the wrong man. But there's that disconnect between what the feds are doing, what the state's doing. They want to keep stuff secret. They don't want to tell you. That was it's a lot of pressure on you as a human being to handle a case in which the state is trying to murder someone.
Well, one more question. So, in regards to judicial activism, do you believe that, and let me define that. I'm sure you've heard the term before. There's a school of thought where there's two debating positions, where one is judges should be advocates and should advocate, and if they believe that laws are unconstitutional or being improperly applied, they should aggressively kind of combat that with their interpretation of law, kind of disregarding case law. And there's the other argument, which some people have, which is they are vehemently against judicial activism because they see it as judges writing law. Do you consider yourself a activist judge? And if so, why?
Well, that whole conversation about judicial activism is a right-wing ploy to cover right-wing judicial activism. I am a constitutional conservative. I believe in the Bill of Rights, and I believe that it's the function of a judge to preserve a citizen's constitutional rights against the might of the state. Now, have there been decisions that have been wrong? Look, as far as I'm concerned, we have the Fourth Amendment, which protects us from unconstitutional searches and requires a warrant. Okay. Currently, there's 14 exceptions to the search warrant requirement. They were all created by conservative judges. We're not judicial activists. Well, wait a minute. You've written into the law 14 ways that citizens can be searched without a warrant. What kind of judicial activism is that? So if I'm saying my reading of the Constitution does not include the automobile exception to the search warrant, and I cogently support that with citations to English law from the 1700s and American law from the 1700s, and I properly do that, if I'm overruled by an appellate court, well, that's life. But that doesn't mean I have to sacrifice my well-schooled, well-supported beliefs about what the Constitution actually means, which it was put there to protect individual liberty and the right to pursue happiness.
Well, I mean, it's interesting when I hear that term judicial activism, because in Louisiana, we're actually under a mixed civil and case law in civil and case law system, and civil systems, which are the majority, I think it's 85% of countries use a civil system. They don't have case law at all. There's no case jurisprudence. Every judge basically interprets the statute as they see it, and precedence does not restrict a judge as far as how they can rule. Now, obviously, there's still an appellate system, but this whole idea that case law and precedent should restrict judges and what they do, it's really an American kind of, it's the way the America has always interpreted the way the judicial system should work. So, I mean, honestly, there's a lot of different arguments why judges should look at every law de novo and look at it and say, I'm going to interpret the law as I see it. And like you said, if you go to an appellate court or a Supreme Court, they have other considerations. But as the district court judge, I kind of agree with you. I think that generally speaking, every judge should look at every case based on its merits, based upon the facts put in front of them, and make a decision that way. But
well, BJ, I just want to say something real quick. In Louisiana, we actually have this one of a kind in the world hybrid system.
Right, hybrid system.
Where our civil law is from the civilian tradition, but our criminal law is from Governor Claiborne. It was brought in as the American system of criminal law.
Right.
So we have this hybrid system, and that was a very cogent observation on your part.
Right. So, and this one I think you'll probably have a lot of opinions on. Do you consider yourself a reform candidate, and if so, why? I don't need to deform what I'm not going to define what a reform candidate is. I think you know that what a reform candidate is, but are you a reform candidate, and why are you a reform candidate?
You know, PJ, I am the reform candidate. You've known me for years. Everyone is where look, the DA's race, right? I ran in 2002. Everyone running for DA in 2020 is running on the Gary Wainwright 2002 DA platform. I'm a progressive in terms of ahead of my time thought leader. I have always been the progressive thought leader in the criminal justice system in Louisiana for 3 decades. Am I a reform candidate? I just think I'm an honest man who works hard, who cares about people. And yes, so in terms of the most incarcerated state on earth, would that make me a reform candidate? I'm an ex-DA. The DA isn't making me a judge. Yeah, I'm a, some people would say, actually some of the judges in the building have said, how far have we come that Gary would be considered the front runner for a judge position?
Okay. How's campaigning during COVID? I know you've campaigned before. I've campaigned before, obviously, but what's been your experience like campaigning during this COVID pandemic?
Well, the first one is what we're doing right now. You know, I told you before we started, when they said we were going to talk, I said, what's the address? And of course, I was sent a Zoom link.
Right.
So, you know, one of the more difficult things, and we've done a lot of forums, Alliance for Good Government and the Democratic Committee and OPDEC and the Forum for Equality and, you know, so many virtual forums. And me as a public speaker, as a trial lawyer, I'm always able, you know, you can, when you're looking at your audience, you can kind of gauge where you're going with what you're saying by the reaction you see on people's faces. And so when you're just looking really at your own face and maybe the moderator, or even if they have 37 little thumbnails that you're looking at while you're talking, it's unique, I guess. It's a new experience. Thank God that we have this technology today. I don't know what else we'd be doing to be responsible in a time of pandemic. You know, but of course, it's been, I think in some senses, it's even better than regular campaigning, because when you're in a forum or in a virtual forum, they give you 2 minutes to say something. In 2 minutes, the moderator presses the button and you're cut off. Unlike the presidential debate, where they went on. Well, unlike the presidential debate.
That's probably why Trump disagreed with doing the virtual debate, because they just would have been pressing the button.
Of course, because they would get to the time, they would cut and he would just be, you know, mouthing.
One more big question, and keep it clean, because I'm telling you, money nasty, but why are you more qualified than your opponents?
Well, there's Miss Stephanie Bridges. Miss Stephanie Bridges has admitted, and I have the video, that she has never represented anyone in a felony criminal case in her 14-year career, which is shocking. Real men go to prison when judges make mistakes, and judges who've never practiced criminal law, or people who have never practiced criminal law, should never be elected judge. Now, Marcus DeLarge, I like Marcus. I mean, I know every judge and every lawyer in the building, of course. I like Marcus. Marcus himself has told me, I have no idea why I'm in this race, Gary. When you told Ike Spears you were going to get Deidre Pierce Kelly disqualified, Ike Spears came to me and told me, Marcus, you're running for judge. I said, what? Now, Marcus has been practicing for a little less than 9 years, and according to him, he's never personally sat first chair in a serious felony criminal trial. And I think given, some more seasoning and a little bit more experience, I think Marcus would have what it takes to be a good judge. I just don't think he's quite there yet. And I don't think his heart was really in this when he got drafted to replace Miss Kelly.
Okay. Is there anything else you'd like to add?
Well, when I ran for judge 14 years ago and I didn't get the support from the community that I had hoped to get, afterwards I was told by a lot of people, Gary, we can't afford to lose you because you're the person that actually stands up for us and speaks truth to power in the criminal district court. I'm 66 years old now, and as much as I'd like to, I can't say that I'm going to be here forever for the community. But if you give me a chance to be a judge and be sitting at the table in those en banc meetings, I guarantee that I'm going to bring change to that building that's going to last for a long time after I'm physically gone from this plane.
Okay. Is there anything else you'd like to add in particular? I know a lot of people want to plug their Facebook or Twitter.
Oh, well, yeah, okay. Thank you for reminding me, PJ. We got Gary Wainwright for wainwrightforjudge.com, where of course you can do all the things you do online. And then of course I have the famous Gary Wainwright Facebook page with 5,000 followers from all different political stripes. Now I have to say that based on the advice I got from a lot of political people, last week I quit posting things about Donald Trump and I'm only focusing on my own campaign. But God, is that hard to stick to because it's 10 times a day. There's a new outrageous thing that is being done to our country by this con man that the Russians installed into the White House. But I'm not talking about that for the next. I'm not talking about that for the next couple of weeks.
All right. Well, thank you so much for the podcast today, Gary. As usual, you've kept it very interesting, and you've given voters a lot to consider. Good luck on the campaign trail.
Well, thank you, PJ. It's just a real pleasure to see you, and before I sign off, I have to say, all of us respect and love you for the work you did in getting that constitutional amendment on the ballot and bringing that real change that we needed so desperately to our state.
Well, thank you very much, Gary. God bless you. Good luck on the campaign trail.
Bye-bye.